Hello and welcome to In Solidum Lawyers. In today's video, we will explore the essential rights of shareholders and how to protect their interests. We welcome you to the complex realm of corporate law, which the position of the shareholder is significantly highlighted, endowed with a specific set of rights and obligations that govern the corporate structure. Within the Ecuadorian legal framework, the company's law represents more than just a collection of regulations. It acts as the fundamental pillar that ensures effective representation of shareholders within the corporate structure. From direct influence through voting rights to legal protection against adverse business decisions, solid guarantees are established for shareholders, both minority and majority, ensuring their equitable participation in the management of the company. In this session, we will explore in detail the principles of this law to expose the essential provisions that every shareholder must know, with the aim of ensuring that their financial investment receives the priority attention it rightfully deserves. Voting rights constitute a fundamental component of the influence that shareholders exert within the corporate structure, serving as an essential democratic mechanism for participation in the company's decision-making. This right is materialized through the assignment of one vote per shareholder, which is crucial in general shareholders' meetings, events, in which significant aspects such as the distribution of profit and the selection of administrators are determined. The effectiveness of this right transcends mere participation. It requires prior preparation and knowledge about the topics to be discussed, the relevance of the proposals presented, and compliance with the legal provisions in force established by the company's law of Ecuador. An informed vote significantly contributes to the development and future direction of the company. For those shareholders who cannot attend the meetings personally, Ecuadorian legislation facilitates the delegation of the vote through a legal power, thus ensuring the representation of their interests. Therefore, it is important for shareholders to recognize the significance of their participation in general meetings, not as mere attendees, but as key players in defining the strategy and operations of the company. And in Solidum Lawyers, our commitment is to ensure that the contribution of each shareholder is valued and has a significant impact on corporate success. The success of a company represents a significant achievement not only for the board of directors and executives, but also for every shareholder who has trusted in its vision. In this context, dividends plays a crucial role as a mechanism for the distribution of earnings to investors. But what exactly are dividends and how do they benefit shareholders? Dividends are the portion of the net profits that a company decides to distribute among its shareholders. This process reflects the fundamental role of shareholders, granting them the right to participate in the earnings distribution proportionally to their investment in the company. It is important to highlight that distribution of dividends is conditioned by the discretion and approval of the General Assembly, which must balance the long-term interest of the company with the adequate reward to its shareholders. Ecuadorian legislation establishes that each shareholder has the right to a proportional part of the profits according to their contribution to the share capital. Additionally, the distribution of profits must adhere to the guidelines stipulated in the company's statutes and comply with all relevant legal and fiscal obligations. There are different forms of dividends: cash, shares, and occasionally special dividends. Each type of dividend has its own characteristics and advantages, depending on the financial situation of the company and the investment strategy of the shareholders. In conclusion, dividends represent a reward for the trust placed in the potential of a company, and are an indicator of its financial health. At In Solidum Lawyers, we are committed to protecting your rights as a shareholder, ensuring that your investment remains profitable. Remember, your active participation in shareholders' assemblies is essential to influence decisions related to dividend policy. Consider the significance of being shareholders in a company without the access to crucial information regarding its operations. Clearly, this will be unacceptable. According to corporate legislation, shareholders in their capacity as co-owners of the company possess the fundamental right as well as the responsibility to be informed about significant aspects of business management. This right to access information is clearly established in the company's law of Ecuador. What specific information are shareholders entitled to? It involves essential documents such as general balances, financial statements, and minutes of general meetings, which provide a transparent overview of the financial situation and strategy of the company. This also includes management reports and any other relevant document that allows shareholders to understand how their investments are being used and the outcomes achieved. It is important for shareholders to be familiar with the procedures for requesting and accessing this information. Typically, these details are discussed in general meetings, but they can also be requested at any time, following the protocols defined by law and the corporate statutes. In cases where the company's management does not voluntarily share this information, shareholders have legal mechanisms to ensure transparency and equitable access to the necessary data. Therefore, we urge all shareholders to actively exercise the right to be informed about the management and performance of the company. At In Solidum Lawyers, we commit to assisting our clients to ensure they always have access to crucial information to protect their investment and contribute to the collective success of the company. In a corporate context, it might appear that minority shareholders play a marginal role in the strategic decisions made at shareholder meetings. However, the corporate legislation in Ecuador grants these shareholders a significant role, ensuring their influence extends beyond mere passive participation. The company's laws of Ecuador provides a special protection for minority shareholders, endowing them with specific rights designed to ensure a balance of power and prevent arbitrary dominance by majority shareholders. Among these rights is the ability to contest decisions deemed unfair or harmful to their individual interests or the general well-being of the company. This ability acts as a control mechanism that, in case of dispute, can be brought before judicial instances for an objective evaluation and resolution in accordance with the law. Additionally, the legislation promotes corporate transparency, granting minority shareholders the right to access detailed information about the activities and financial performance of the company. This access to information is crucial for informed participation in corporate decisions. In critical situations that may determine the company's future, such as mergers or sale of significant assets, the active participation of minority shareholders is assured, whose vote is indispensable for the approval for such actions. Therefore, minority shareholders are invited to exercise their rights confidently, knowing that Ecuadorian legislation supports a valuable contribution to the management and direction of the company. At In Solidum Lawyers, our commitment is to ensure that these rights are respected and protected, recognizing the importance of each stake in business success. In situations where corporate regulations are breached and shareholders' rights are violated, there are still effective solutions pathways available. Shareholders in Ecuador have at their disposal various strategic resources to protect and defend their interests within the corporate legal framework. Initially, direct communication and negotiation with the company's management are recommended as methods to resolve disagreements or misunderstandings amicably. This approach often leads to conflict resolution without the need for formal procedures. However, if these attempts at dialogue fail to restore shareholders' rights or their interests continue to be disregarded, convening an extraordinary general meeting may be considered. This meeting allows shareholders to discuss and vote on contentious issues seeking a collective resolution. In cases where these actions do not yield the desired result, shareholders may resort to legal measures. A key legal recourse is the social liability action through which shareholders can sue administrators for behaviors resulting in detriment to the company. This mechanism aims not only to repair the damage caused but also to deter future harmful actions. Additionally, Ecuadorian legislation provides other legal tools, such as the action to challenge resolutions adopted at a meeting that are considered illegal or contrary to the company's statutes. For more complex situations, mediation and arbitration procedures offer an alternative for conflict resolution in a more efficient and less contentious manner, with an impartial third-party arbitrator tasked with making a decision based on the evidence and arguments presented by the parties. In conclusion, shareholders have a set of legal resources to safeguard their rights and interests within the corporate structure. And in Solidum Lawyers, we are committed to providing advice and support at every stage of the process to defend your rights, emphasizing that each legal action is vital for the protection of your interests. With this, we conclude our presentation on corporate law. It is important to acknowledge that shareholders play a crucial role in the capital contribution and in driving the growth and sustainability of the company. Familiarizing oneself, understanding, and properly exercising one's rights not only constitutes a fundamental financial responsibility, but is also essential for the development of corporations characterized by their transparency, fairness, and success. If this presentation has sparked new queries or desires to delve deeper into these topics, we invite you to share your comments, questions, and experiences. Your active participation significantly enriches this forum. If you find value in our content, we would appreciate your support with a like, subscribing to the channel, and activating notifications to continue receiving relevant and up-to-date information. We deeply appreciate your membership in our community and look forward to meeting again on future occasions. For those interested in delving deeper into commerce and corporate law, In Solidum Lawyers stands as your primary support. We invite you to contact us for personalized advice, as our greatest commitment is the protection of your investments and rights. Visit our website for more information on how we can collaborate in achieving your business objectives. We hope to have the opportunity to assist you soon in your corporate challenges.